Welcome to the Recipient Rights Training. The Office of Recipient Rights is located at 421 West 5th Avenue. Our contact information is listed below. Please note that this video training is accompanied by a PDF handout. It is very important to review the handout for further details on the subject matter as well as for examples. A recipient is an individual who receives mental health services from the Michigan Department of Health and Human Services, a community mental health agency, such as Genesee Health System, or from a facility or a provider that is under contract with either MDHHS or a CMH agency. If you're watching this training video, you are a provider of services to GHS recipients. But what is a right? A right can be defined as that which a person is entitled to have, to do, or to receive from others within the limits prescribed by law. The rights described in this training are protected in various state and/or federal laws, including the Michigan Mental Health Code and Administrative Rules, the U.S. and Michigan Constitutions, as well as other federal laws such as the Americans with Disabilities Act. The Mental Health Code requires that each Community Mental Health Services program establish an Office of Recipient Rights, or ORR. The functions of the ORR are divided into 4 areas: education and training, prevention, monitoring, and complaint resolution and investigations. When a recipient rights complaint is received, the ORR reviews 3 factors in order to determine whether the complaint is appropriate for the ORR. Firstly, is the individual whose rights were allegedly violated a GHS recipient? In order for the ORR at Genesee Health System to have jurisdiction over a complaint, the involved recipient must be a GHS recipient. Secondly, is the complaint about some aspect of the recipient's mental health services? In order for the complaint to be appropriate for the ORR, it must involve some issue pertaining to the recipient's mental health services, that is, something that Genesee Health System is paying for. And lastly, does the complaint involve a mental health code protected right? In order for the complaint to be appropriate for the ORR, it must involve a legal right to which the recipient is entitled as a recipient of mental health services. The conclusions of the ORR within an investigative report are based upon the preponderance of evidence. This means evidence which is of greater weight or more convincing than the evidence which is offered in opposition to it. That is, evidence which, as a whole, shows that the fact sought to be proved is more probable than not. When a recipient rights investigation begins, the investigator will have access to all evidence necessary to complete the investigation. This means that staff are required to comply with the recipient rights investigative process, including providing any documentation or other evidence requested by the ORR. Staff are also required to cooperate fully with any investigative interview requests by the ORR. Answers provided by staff during these interviews must be accurate and honest. Any failure to cooperate with the recipient rights investigative process will result in disciplinary action against the staff person involved. The Mental Health Code requires that an investigation be completed within 90 days of the receipt of a complaint. Each investigation culminates in the issuing of a report of investigative findings. This report is submitted to the Genesee Health System CEO as well as the service provider. If a recipient rights violation is substantiated, remedial action is required from the service provider to correct or remedy the violation and to prevent recurrence of the rights violation. It is also required that the remedial action be implemented in a timely manner. Within 10 days after receiving the report of investigative findings, the GHS CEO issues an investigative summary report, summarizing the investigation, and submits it to the complainant and the recipient, and, if applicable, to the guardian or parent of a minor recipient. Each of these parties have certain appeal rights as well. An appeal of a recipient rights investigative summary report must be filed in writing and directed to the GHS Recipient Rights Appeals Committee. It must be submitted within 45 days of the receipt of the investigative summary report. An appeal must be based only upon the following grounds. 1. The findings of the investigation are inconsistent with the law, rules, policies, or guidelines. 2. The action or plan of action is inadequate. And 3. The investigation was not initiated or completed in a timely manner. The Mental Health Code requires that each community mental health agency appoint a Recipient Rights Advisory Committee consisting of at least 6 members. 1/3 of the membership must be either primary consumers or family members, and of that 1/3, at least half must be primary consumers. It is the committee's responsibility to advise the agency's CEO and the director of the ORR on rights-related matters. It also protects the ORR from pressures that could interfere with the impartial, even-handed, and thorough performance of its functions. The committee also reviews and provides comment on the GHS ORR annual and semi-annual reports. The GHS Recipient Rights Advisory Committee also serves as the GHS Recipient Rights Appeals Committee. There are various mental health code sections that pertain to recipient rights. The Mental Health Code requires that providers prevent and correct civil rights violations. Examples of civil rights are the right to participate in an official election, the right to practice one's religion, the right to be presumed competent unless a guardian has been appointed, and the right to be free from a legal search or seizure. Additionally, the Mental Health Code requires that a person-centered planning process be used to develop a written individual plan of services in partnership with the recipient. A preliminary plan must be developed within 7 days of the commencement of services. The person-centered planning process builds upon the individual's capacity to engage in activities that promote community life and honors the individual's preferences, choices, and abilities. The person-centered planning process involves families, friends, and professionals as the individual desires or requires. The individual plan of services, also known as the person-centered plan, is the fundamental document that guides the treatment of a recipient. It identifies the goals that the recipient would like to work on. These goals must be meaningful and measurable. The plan must address, as either desired or required by the recipient's need for food, shelter, clothing, health care, employment opportunities, educational opportunities, legal services, transportation, and recreation. The plan must be kept current and must be modified when indicated. If a recipient is not satisfied with their individual plan of service, a request may be made for review of the plan. The review must be completed within 30 days of the request. Any limitation on a recipient's rights must be identified in the individual plan of services. The Mental Health Code requires that limitations on recipients' rights be justified, time-limited, and clearly documented in the plan. The plan must also document attempts that have been made to avoid the limitation and what actions will be taken to ameliorate or eliminate the need for that limitation. Additionally, any limitation on recipient rights must be reviewed and approved by the GHS Behavioral Treatment Plan Review Committee prior to its implementation. Applicants for and recipients of mental health services must be provided an accurate summary of their rights. Recipients are verbally informed of their rights and also provided with a Your Rights booklet. The summary of rights is given at the time services are first requested or initiated, as well as annually during the time services are provided to the recipient. Written verification of this notification of rights must also be filed in the recipient's record. The Mental Health Code requires that a recipient receive mental health services suited to his or her condition. In other words, the recipient must be provided services in accordance with his or her individual plan of services. Staff members providing services to a recipient are required to read, understand, and implement the plan of services as written. Another important right is the right of residents to receive, possess, and use all personal property, including clothing and money. Any limitation on this right must be documented in the plan of services as previously stated. Limitations can be implemented only in order to prevent theft, loss, or destruction of property, unless a waiver is signed by the resident, or in order to prevent the resident from physically harming himself, herself, or others. A very important right is the right to be treated with dignity and respect. Dignity and respect issues are some of the most common issues dealt with by the ORR. Under the Mental Health Code, both recipients and family members have the right to be treated with dignity and respect. A family member is defined as a parent, step-parent, spouse, sibling, child, grandparent, or an individual upon whom a primary consumer is dependent for at least 50% of his or her financial support. Given the importance of the right to be treated with dignity and respect, these terms are defined in GHS policy. The definition for dignity includes to treat with worthiness, honor, or importance. It can also mean to address someone in a manner that isn't patronizing, condescending, or demeaning. The definition for respect includes to treat courteously, to show regard or consideration for, or to treat with high or special regard. It can also mean to afford a recipient appropriate privacy. In most cases, mental health services can be provided only with consent. Consent means a written agreement executed by a recipient, a minor recipient's parent, or a recipient's legal representative with authority to execute a consent. It can also mean a verbal agreement of a recipient that is witnessed and documented by an individual other than the individual providing treatment. Informed consent has 4 elements. 1. Legal competency. The individual being asked to consent must be presumed to be legally competent unless a guardian has been appointed for him or her. 2. Knowledge. A recipient or his or her legal representative must have basic information about the procedure, risks, and other related consequences, and any other relevant information in order to make an informed decision. 3. Comprehension. An individual must be able to understand what the personal implications of providing consent will be based upon information provided to him or her. And 4. Voluntariness. The individual must have free power of choice. There can be no element of force, fraud, deceit, or duress. The individual must also be instructed that he or she can withdraw consent and discontinue participation at any time. The rules around informed consent apply to medication administration as well. Before initiating a course of psychotropic drug treatment for a recipient, a prescriber or a licensed health professional acting under the delegated authority of the prescriber must explain the specific risks and the most common adverse effects. They must also provide the individual with a written summary of the most common adverse effects associated with that drug. Section 748 of the Mental Health Code speaks to recipients' rights to confidentiality. It specifically states information in the record of a recipient and other information acquired in the course of providing mental health services to a recipient shall be kept confidential and shall not be open to public inspection. In addition to the Mental Health Code's protections around confidentiality, GHS policy further limits access to confidential information within GHS and its contract providers. GHS confidentiality policy states, internal access to confidential information, that is, access within GHS or within a contract provider, and external access to confidential information, that is, between GHS and a contract provider, shall be limited to those staff who have a need to know that specific information in order to perform their assigned job duties. But what constitutes confidential information? GHS policy defines confidential information as all information in the record of a recipient, as well as any information acquired in the course of providing mental health services to a recipient. This includes, but is not limited to, information acquired in diagnostic interviews or examinations, results and interpretations of tests ordered by a mental health professional, and entries or progress notes by mental health professionals and supporting personnel. When it comes to disclosures of confidential information, there are 3 different types of disclosures. Mandatory disclosures are situations where information must be disclosed. An example would be in response to a valid subpoena. Then there are discretionary disclosures with consent. These would be situations where information may be disclosed, but only with consent. An example would be to a mental health services provider. Lastly, there are discretionary disclosures, situations in which information may be disclosed even without consent. An example would be to the police if there is a compelling reason to do so based upon a substantial probability of harm to the recipient or others. It is important to note that representatives of Disability Rights Michigan, formerly known as Michigan Protection and Advocacy, can access a recipient's record if they have received a complaint on behalf of a recipient or if they have probable cause to believe that the recipient has been subject to abuse or neglect. Here are some examples of instances when it is appropriate to disclose information about a recipient. When the recipient agrees and signs a release of information. To mental health or other public agencies, for instance the police, when there is a compelling reason to believe that there is a substantial probability of harm to the recipient or others. To other agencies such as Social Security or the Department of Health and Human Services when necessary in order for the service providers to receive payment. When required by court order or to comply with the law. To a prosecuting attorney when necessary to participate in proceedings governed by the Mental Health Code, for example, civil commitment proceedings. To the recipient's attorney when the recipient is given consent. To the surviving spouse of a recipient in order to apply for and receive benefits, but only if the surviving spouse has been appointed personal representative of the estate by the court. Emergencies and duty to warn. Please consult agency policy in these situations. Confidentiality is one of the most important rights a recipient has. Here are the key things to remember. All information in a person's record and any information about the person obtained while you are providing services is confidential. Informed consent from the recipient or the recipient's guardian is required before giving out any information, with rare exception. There are confidentiality rules inside the agency. Information can be shared within the agency as necessary for one to do their job. A good guide when thinking about confidentiality is think about what your expectations would be for confidentiality if you were receiving mental health services. The Mental Health Code states that residents of facilities have the right to unimpeded, private, and uncensored communication with others by mail and telephone, and to visit with persons of their choice. Telephones must be reasonably accessible to residents, and it must be ensured that correspondence can be received and mailed. Space must also be made available for residents to receive visitors. As previously stated, any limitations on a resident's rights to communicate or to receive visitors can be implemented only as allowed in the individual plan of services, following review and approval by the GHS Behavioral Treatment Plan Review Committee and with consent. The Mental Health Code also states that mental health services must be provided in a safe, sanitary, and humane treatment environment. Accordingly, GHS's client services contracts require that contractors monitor and ensure the safety and welfare of clients while they are under the contractor's service supervision pursuant to the contract. This also includes a requirement to seek and assure immediate medical attention for any client who needs it. The Mental Health Code states that a recipient of mental health services shall not be fingerprinted, photographed, audio recorded, or viewed through one-way glass, except under certain circumstances. The definition for photographs includes still pictures, motion pictures, and video recordings. Photographs of recipients can be taken only in order to provide mental health services to a recipient, including research, for educational or training purposes, or to determine the name of a client, and only when prior written consent is obtained from either the recipient, if 18 years of age or over and competent to consent, the guardian of the recipient, or the parent with legal and physical custody of the recipient, if the recipient is less than 18 years of age. Consent for photographs may be withdrawn at any time. The Mental Health Code also contains provisions for recipients to have choice in mental health professional. It states, a recipient shall be given a choice of physician or other mental health professional in accordance with the policies of the Community Mental Health Services Program, licensed hospital, or service provider under contract with the Community Mental Health Services Program. GHS policy on services suited to condition contains similar language and states that the choice of mental health professional must be in accordance with GHS standards and within limits of available staff. Requests for a change in mental health professional may be made through the GHS Customer Services Office or through the professional supervisor. The Mental Health Code states that services must be offered in the least restrictive setting that is appropriate and available. Additionally, there are freedom of movement provisions in the Mental Health Code. A recipient's freedom of movement cannot be restricted more than is necessary to provide mental health services to him or her, to prevent injury to him or her or others, or to prevent substantial property damage. According to the Mental Health Code, residents of facilities have certain rights related to accessing entertainment materials, information, and news. A provider cannot prevent a resident from acquiring these things at his or her own expense, or from reading written or printed materials, or from viewing or listening to television, radio, recordings, or movies made available at the facility for reasons of or similar to censorship. A provider may limit access to entertainment materials, information, or news only if such a limitation is specifically approved in the resident's individual plan of services. The Mental Health Code also explicitly prohibits the use of both seclusion and restraint in any setting other than MDHHS operated or licensed hospitals. This means that neither seclusion or restraint can be used in adult foster care homes or other community settings. Seclusion is defined as the temporary placement of a recipient in a room alone where egress is prevented by any means. An example would be a recipient's inability to exit a bedroom due to the door being locked or the exit being intentionally obstructed. Restraint is defined as the use of a physical device to restrict an individual's movement. Note that restraint does not include the use of a device primarily intended to provide anatomical support. The Mental Health Code states that a recipient shall not be subject to abuse or neglect. The specific definitions for abuse and neglect are found in the MDHHS administrative rules. There are 3 classes of abuse and 3 classes of neglect, Class 1 being the most serious in each category. Abuse Class 1 is defined as a non-accidental act or provocation of another to act which caused or contributed to the death, sexual abuse, or serious physical harm of a recipient. There are 5 subtypes of Abuse Class 2. The first type is defined as a non-accidental act or a provocation of another to act which caused or contributed to non-serious physical harm of a recipient. The second type is defined as use of unreasonable force on a recipient, with or without apparent harm. Unreasonable force will receive more explanation in subsequent slides. The third type of Abuse Class 2 is defined as any action or provocation of another to act which causes or contributes to emotional harm to a recipient. The fourth type is defined as an action taken on behalf of a recipient by a provider who assumes the recipient is incompetent despite the fact that a guardian has not been appointed, which results in substantial economic, material, or emotional harm to the recipient. Lastly, the fifth type of Abuse Class 2 involves the exploitation of a recipient. The concept of exploitation will be further defined in a subsequent slide. Unreasonable force, which is the second type of Abuse Class 2, is defined as physical management or force that is applied to a recipient in one or more of these circumstances. 1. There's no imminent risk of serious or non-serious physical harm to the recipient, staff, or others. 2. The physical management used is not in compliance with approved techniques. 3. The physical management used is not in compliance with authorized emergency interventions in the recipient's individual plan of services. Or 4. The physical management or force is used when other less restrictive measures were possible but not attempted. Physical management, one of the elements of unreasonable force, is a technique used by staff as an emergency intervention to restrict the movement of a recipient by direct physical contact in order to prevent the recipient from harming himself, herself, or others. A few important things to remember when it comes to physical management. It can be used only in situations where lesser restrictive interventions were unsuccessful in reducing or eliminating the imminent risk of harm. Physical management will not be included as a component in a behavior treatment plan. Lastly, prone immobilization of a recipient, that is, holding someone in a face-down position for the purposes of behavior control, is prohibited. Exploitation, the fifth subtype of Abuse Class 2, is an action by an employee, volunteer, or agent of a provider that involves the misappropriation or misuse of a recipient's property or funds for the benefit of an individual or individuals other than the recipient. By way of example, exploitation can include the theft or misuse of a recipient's personal funds, misuse of their bridge card or credit card, or even their prescribed medications. Abuse Class 3 is the use of language or other means of communication to degrade, threaten, or sexually harass a recipient. Sexual harassment includes sexual advances to a recipient, requests for sexual favors from a recipient, or other conduct or inappropriate communication of a sexual nature toward a recipient. As previously mentioned, there are three classes of neglect. What is common to each class is that there is an act of commission or omission by a staff person, meaning the staff person did something they should not have done or did not do something they should have done. And that act was in non-compliance with the standard of care, for example, a law, policy, directive, or a requirement from the individual plan of services. And that act caused or contributed to physical harm or risk of harm to the recipient. On this slide, we see the distinctions between the three classes of neglect based upon the level of physical harm sustained by the recipient. Neglect Class 1 is defined as acts of commission or omission by an employee, volunteer, or agent of a provider that results from non-compliance with the standard of care or treatment and causes or contributes to the death or sexual abuse of or serious physical harm to a recipient. Class 2 is again defined as acts of commission or omission by a staff person, again resulting from non-compliance with the standard of care, but it causes or contributes to non-serious physical harm or emotional harm to a recipient. And lastly, Neglect Class 3 is defined again as acts of commission or omission by a staff person, again resulting from non-compliance with the standard of care, but it places or could have placed the recipient at risk of physical harm or sexual abuse. The definitions for neglect also include recipient rights reporting requirements. It is important to understand the rules related to reporting abuse and neglect. Firstly, verbal reports of abuse and neglect must be immediate. Waiting, for instance, until the shift is over or until the next business day does not meet the standard. Also, the verbal report must be made to both the Office of Recipient Rights and the staff person's supervisor. Please note that this is not an either-or situation. Both the ORR and the supervisor must be contacted. In terms of what must be reported, any apparent, suspected, or alleged violation must be reported. This means that even allegations that a staff person might consider to be rumor or hearsay must be reported. One other important thing to note, filling out a critical incident report, although appropriate in instances of abuse and neglect, does not take the place of the immediate verbal report to the Office of Recipient Rights. Failure to report is addressed within the neglect definitions as follows. The failure to report alleged, apparent, or suspected abuse Class 1 or neglect Class 1 is itself neglect Class 1. The failure to report alleged, apparent, or suspected abuse Class 2 or neglect Class 2 is itself neglect Class 2. Likewise, the failure to report alleged, apparent, or suspected abuse Class 3 or neglect Class 3 is itself neglect Class 3. The Mental Health Code prohibits harassment and retaliation against those involved in recipient rights activities. This includes complainants, staff from the Office of Recipient Rights, recipients, and any staff person acting on behalf of a recipient and/or involved or who may become involved in recipient rights activities. The definition of harassment is words, gestures, or actions which threaten an individual, attempt to intimidate, coerce, or inappropriately influence those involved or who may become involved in recipient rights activities, unreasonably interfere with an individual's work performance, or create an intimidating, hostile, or offensive situation. Retaliation is defined as unjustified negative actions taken against an individual involved or who may become involved in recipient rights activities. Disciplinary action is required if there is any evidence of harassment or retaliation. If there are any questions related to the issues addressed in this training or to recipient rights in general, please feel free to call the GHS Office of Recipient Rights at any of these numbers.